May it please the court, my name is Rebecca Nicol, and I appear on behalf of the plaintiff, Miss Chloe Brown, instructed by Maddox. This is an application made pursuant to a notice of motion filed on 30th of August, supported by the affidavit of myself, sworn on 31st of August. I seek three primary orders today. One, that the notice to produce served by the defendant's solicitors on 19 March 2025 be set aside or amended. Two, that the hearing listed to commence on 21 October 2025 be vacated and adjourned due to the unavailability of a key expert witness. Three, ancillary orders as to costs, including costs of the motion and costs of the vacation, if granted. Your Honour, the first limb of my application is to seek that the court set aside or amend the notice to produce served on the plaintiff. This is made pursuant to UCPR Rule 33.4, which allows the court to set aside or limit the scope of a notice to produce on the basis that it is oppressive, unfair, or constitutes an abusive process. I submit that several parts of the notice served by the defendant meet that threshold. Specifically, the request for the complete medical history of Mr. Oliver Brown, who is not a party to the proceedings and whose health is irrelevant to any live issue. The demand for all of Chloe Brown's medical records covering her entire life is unreasonably broad and not proportionate to the issues in dispute, which are confined to the nature and extent of the injury sustained in the subject incident. The demand for production of building documents that are neither in the plaintiff's possession nor relevant and could be obtained through the defendant's own inquiries. The request for witness statements prepared by legal representatives, which I submit are privileged. Under Rule 21.81 of the UCPR and Section 119 of the Evidence Act of 1995, New South Wales. Your Honour, the notice seeks documents not discoverable, and the request is made in broad and general terms. Contrary to established authority in Interchase Corporation Limited and Grosvenor Hill, which supports that a notice to produce must be for specific relevant documents. We rely on the principles of proportionality and efficiency under Section 56 of the Civil Procedure Act, which mandates that litigation be conducted in a way that is just, quick, and cheap. This notice in its current form offends all three limbs of that test. Accordingly, we seek that it be set aside or, in the alternative, amended to limit Chloe Brown's medical records to those from 2 years prior to the incident to present and exclude documents not in her possession or control. Exclude documents covered by legal professional privilege. The second limb of this application seeks to vacate or adjourn the hearing set for 21 October 2025. This is due to the serious and unavoidable unavailability of our expert medical witness, Dr. Frankenstein, who was due to give concurrent evidence alongside the defendant's expert, Dr. Zeus. Your Honour, as set out in the affidavit, Dr. Frankenstein has recently been diagnosed with cancer and is scheduled for urgent surgery on 18th of September 2025, followed by a course of chemotherapy. Medical advice confirms she will be unfit to attend court or participate via audio-video link, and no suitable substitute has been identified in the time frame. This application is made under the court's inherent case management powers and Rule 2.1 of the UCPR, as well as Section 57 of the Civil Procedure Act, which gives the court wide powers to give directions to manage proceedings justly and efficiently. We accept that adjournments are not granted lightly. However, the unavailability of Dr. Frankenstein is genuine, unavoidable, and not due to any fault or delay by the plaintiff. Indeed, we have acted promptly to inform the court and the defendant, and have filed this motion as soon as the circumstances became clear. The case of Aon Risk Services Australia Limited and ANU reminds us that delay and adjournments must be justified and balanced against the overriding purpose. But in Thomas and SMP International Proprietary Limited, the court confirmed that where an adjournment is necessary to ensure a fair trial, especially where key expert evidence is affected, the court may grant it. Your Honour, without Dr. Frankenstein's evidence, Chloe Brown would be severely prejudiced, as the medical causation and severity of her injuries are live and contested issues. Denying the adjournment would materially undermine the fairness of the trial. We submit the hearing be vacated and relisted for a 3-day hearing. We are prepared to provide the court with alternative dates based on counsel and witness availability. Week of 9 February 2026, week of 23 February 2026, or week of 2nd of March 2026. These dates have been canvassed with counsel and all expert witnesses, subject to the court's availability. Your Honour, we are conscious that vacation of the hearing may result in costs thrown away, and we are not resisting the defendant's entitlement to seek costs of the hearing vacated, limited to costs reasonably incurred in preparation to date. We submit each party bear their own costs of the motion to set aside the notice to produce. The defendant be entitled to reasonable costs thrown away by the vacation as agreed or assessed. This reflects the just outcome. In line with Section 60 of the Civil Procedure Act, which empowers the court to make such orders as to costs as are fair in the circumstances. In summary, Your Honour, we seek the following. 1, an order that the notice to produce served by the defendant on 19 March 2025 be set aside, or, in the alternative, varied in accordance with the submissions made. 2, an order vacating the hearing listed for 21 October 2025 with a relisting in one of the available dates proposed. And 3, ancillary orders. Each party bear their own costs of this motion on the notice to produce, and the defendant have costs thrown away by the vacation of the hearing as agreed or assessed. Unless Your Honour has any questions or requires clarifications, those are my submissions. May it please the court.